Warren Cabral. I'm the managing partner of the London office of Appleby. Appleby is an offshore law firm, which is to say we specialize in the jurisdictions that you see represented here today. I am here together with David Clark, who's my partner in our London office, and also Oboshi is in our London office. We have James Godin from our Jersey office, but today representing our Guernsey office, a partner out there, and Kyle from our Isle of Man office, who will speak about the Isle of Man. So a nice, neat connection there. The firm itself, as I say, specializes in the offshore jurisdictions. We practice Bermuda, British Virgin Islands, Cayman Islands, Guernsey, Jersey, Isle of Man, Mauritius and Seychelles law, but from onshore jurisdictions as well, which is to say, in addition to the offices we have offshore, we have a London office, a Zurich office, a Hong Kong office as well. So in any of those places, you will find any one of us standing ready to talk to you about taking security, financing using offshore vehicles. So those are entities created offshore for the purpose of participating in transactions. And what we're going to do today, having briefly introduced you to my team, is have a sort of a competition, if you will, between each of those offshore jurisdictions who'll be bidding for a slice of a particular artificial transaction which we've created just by way of illustration. And what I'll do is flash through the slides. Don't dwell too long on the individual slides. They're just there to illustrate the construct. The elements of the construct may or may not be real life, but they're intended to show you how each of these jurisdictions can be used, and for each of them then to compete between themselves for very glamorous prizes, I think. You told me that it's really glamorous.
We'll see at the end what the prize is.
Well, so far we've been given a biro, your biro in fact, to use as a prize. But so, as I say, we cover Bermuda, BVI, Cayman, Jersey, Guernsey, Isle of Man, Mauritius and Seychelles. And representing them, we've got Oboshi, who is at the far end there. She will be representing Mauritius and Seychelles, and this is a highly coveted job, I must say. I've been to both places, and although I was born in Bermuda, I can honestly tell you, that prejudges one of the competitions at the end in which you get to participate. And British Airways has given me a little envelope to present. So it's something that you might.
That may or may not be true.
Well, this is, as I said, it's an artificial construct, the entire thing. So is the British Airways envelope. But as an overview of all of those I beg your pardon, I didn't finish my introduction. So we've got your own colleague there, Francis, who's going to speak for Jersey today, having had a lengthy briefing. I saw him furiously doing his notes. James speaking for Guernsey. Then we have Alison, who's going to speak for Bermuda. And I should be listening very carefully. I'm a native Bermudian, so I will be testing you afterwards. We have Kyle, as I say, speaking for the Isle of Man, and next to me on this side is Amber, who will speak for Cayman, and David, who's going to speak for the British Virgin Islands. And you worked
I did indeed.
In the British Virgin Islands.
Yes, for my sins.
It would be. It would be. Being a competitor island as a native, to me, anywhere else is nowhere near as perfect. But I don't want to prejudge your questions and answers and your competition at the end. Now, what unites all of those jurisdictions is, first of all, the role that they play in offshore finance, or in the finance world generally, typically as an arbitrage between either two things, either the tax regimes of the onshore world or the regulatory regimes. I mean, their purpose is very much to pick up the differences and also to serve as kind of a neutral flow-through. So, for example, except for Mauritius and Seychelles, which have double taxation treaties with numerous countries, the other islands do not. And so where typically, let's say, stepping outside of the example we're going to be using for a moment, where you have, let's say, an American and a Brit doing business, they will have double taxation treaties. So therefore, it is not necessary if you have an entity in the middle which is arbitraging a regulatory rule, for example, that would be a very typical reason, you won't want to have an additional layer of taxation introduced. So you will have these neutral, as we call them, tax-neutral jurisdictions serving as a flow-through conduit where you have double taxation arrangements on either end.
We don't use the term tax haven, but we don't recognize that term.
No, we don't, and for a reason, because, and this is, you'll see on the list here, not that you need to commit these to memory, but the expression tax haven conjures up a lot of negative images of evasion as opposed to the neutrality. So all of the well-regulated jurisdictions, and I pause here to say that every one of them here represented, Bermuda, BVI, Cayman, Mauritius, and so forth, all of them are in the top tier of whitelisted jurisdictions. Now, you may or may not be familiar with an exercise that's been going on for about 4 or 5 years now with OECD, with the Financial Action Task Force, European Union. A lot of the international and national bodies have been working on a series of harmonizing steps for harmonizing the approach, not necessarily individual rules, but the approach that the main economies take towards each other, and which will then sweep up all of the smaller countries around the world. And what they did in that approach was to have lists of countries which disclose or reach particular standards which were developed by the OECD itself in terms of disclosure of the ownership of companies, the willingness to cooperate with other tax authorities, and they came up with 3 lists: a white list, a grey list, and a black list. So those who comply with or cooperate with the OECD, those who are en route to doing so, and those who either do not or will not cooperate. Now, all of our jurisdictions are on that white list and have, as a minimum, 12 what they call tax information exchange agreements with other countries. So what that means is on a request basis, so it's not automatic disclosure. Very few countries within the European Union, there's between the European Union members some automatic disclosure, but most countries in the world have an on-request basis where you've got a suspicion of a crime, for example. So with those agreements in place, another country's taxing authorities can go and ask for the disclosure of information. So that is what puts all of our jurisdictions on the white list. But apart from that, there are many lists or indices of the ways in which particularly the offshore countries cooperate in terms of both their tax regimes, their general legislative framework, and the way it fits in with the international financial scheme. And all of our jurisdictions are highly rated for the way that their legal systems operate, the way the courts operate, the way that you can get judgments enforced in each of those jurisdictions, and the efficiency with which a foreign entity seeking either information or cooperation with an offshore jurisdiction can actually achieve that. And that's because most of them, except possibly for Seychelles, and obviously each of us will speak to specific jurisdictions, but most of the jurisdictions have a British common law tradition. So these are well-established principles. Mutual recognition of judgments is possible between most of them. So you'll find that if you were to go to any one of our jurisdictions, there'd be a broad body of the law which will be immediately recognizable to you. There's a local overlay of statute which each of our panel members will discuss as we go through. But broadly speaking, they're all very similar. Mauritius and Seychelles have a slightly odd history with French and English or British occupation at various times, so they have hybrid systems, which I'll leave Oboshi to speak to. But let's not, however, miss the fundamental point, is that each of those jurisdictions that we're representing today do have lower tax rates than the onshore world, and that is what serves as that point of arbitrage that I mentioned. So despite those similarities, there are, of course, big differences. And those differences are what we're going to tease out today, so which entitles me now to take you to our artificial construct transaction for the purpose of enabling each of these jurisdictions to compete for a slice of a deal, in the same way that we as law firms compete against other law firms for a client's instructions, so too each of us today are going to compete. Well, not me, I'm sitting here moderating and giving out the prizes, but these colleagues of ours will compete for a slice of the deal. And our construct is the Dutch Star reorganization for the purpose of transferring one of its existing subsidiaries called Starfish to another place within a new structure for the purpose of obtaining a better tax structure for itself. In order to effect the reorganization, they need to borrow money from a European bank, and that bank is the client of shall we say, of Appleby. But that is the person driving the transaction is the European bank, which will finance this reorganization. That particular client has, as we'll see, set out a number of criteria which are mandatory from its perspective. So our job today is not to say to the client, well, you could be doing this a better way, or that element of the transaction is not as important, so why are we worrying about it? But we're being asked, as part of our construct, just to accept the slides that you'll see, the structure that you'll see, as being what the client wants. And they've laid down a number of criteria, and what we'll be doing, or what the panelists will be doing, is pitching for a particular slice of the transaction based on the key criterion identified at that stage of the deal. So I'll articulate to you what the criterion is, and then each country, each jurisdiction will bid for that portion of the deal based on that criterion. And I'll announce at the end who the lucky winner is. So as I say, Dutch Star is going to acquire an interest in Starfish. Well, really, it's going to reorganize itself so as to hold its interest in Starfish. And our client, the bank, which is driving the transaction, has given us the following instructions, which, as I say, we can't depart from. So it's urgent, so we'll have to see which jurisdictions can meet the time is money criterion. We can't change the deal, so it's not up to me to pick holes into the whys and wherefores of what they're doing. There are to be 5 entities, hence 5 of our 8 jurisdictions, lucky jurisdictions, will be winners. And each of our offshore entities have specific requirements that they'll have to meet. So we'll be determining which are the appropriate jurisdictions. That's what we're going to look like during the course of the restructuring. We're going to be swapping. You don't need to memorize this, by the way. Please relax. No notes need to be taken. Just try to enjoy the cut and thrust. Certainly I will, since I'm not involved in that bit. And we're going to end up, that's the financing and security structure. And a big part of what we'll be talking about is the security. And that really, actually, pausing for a moment and in all seriousness, you as practitioners are likely most often to encounter the security side of going offshore. You'll be involved in a financing. Quite often some of the entities, as we'll see, will be incorporated offshore, and you will want to take some sort of security. So we'll be spending some time on that as well. But that's the only bit that really would relate to your day-to-day practice as far as I can see. And then that's where we're going to end up. The final ownership structure is going to look something like that. As you can see, there are a number of entities, 5 of them there, which have to be slotted into the structure in that order, and for the reasons which we'll come to. Now, first set of reasons. In the first leg, and I won't flash back to the structure, the first leg that we've got to put in place in the finance leg, we've got a note issuer to the bank, the borrower effectively, and they require a restricted purpose company. I'll leave the panelists to explain wholly what that might mean, but essentially the bank will want to be assured that its borrower isn't going to run off and do anything else bar this particular transaction. So the purpose to which the borrower note issuer is restricted is that transaction only. So that's why it's called a restricted purpose company. And the other aspect is that the acquisition must be tailored to the needs of the bank itself. So the bank wants to be assured that the company can't act outside its objects, and the bank will be confident that its transaction will be exactly as described on paper. So that's the next one. So what I now get to do is to turn, and this is an extraordinary thing for a lawyer to have to admit to, but I've been handed something called a cheat sheet. So you're looking at a bunch of cheats here because each of us have a copy. And what I'm going to ask each of our panelists to do, and David's going to tell me in which order I should do it, whether I do left to right, right to left, starting on my right, ask each of our jurisdictions to speak to the concept of a restricted purpose company. So we're going to start with David, who's going to tell us about the ultra-vires rule a bit and the time of incorporation. Also, if you remember, an important criterion. Urgency, if we remember this, the initial criteria, urgency, time to market is very important. So starting with David and then working our way along, if you could tell us about restricted purposes and time to market.
Well, representing the British Virgin Islands today, apologies if my placard is covered up, but I'd like to thank the other panelists representing the other jurisdictions, particularly Cayman and Guernsey, for turning up and for competing with respect to this particular SPV. The client has mentioned quite clearly that they require a restricted purpose company. The British Virgin Islands is the only jurisdiction amongst those present here today that offers a creature called a restricted purpose company, which means effectively that a company can entrench its objects in its memorandum of association and articles. That means that they cannot be changed by either a resolution of directors or a resolution of shareholders, and that will provide the requisite comfort that the client is looking for. Now, some of the other jurisdictions, I think it will be Cayman and Guernsey, will regale you with stories of special purpose companies with flexible objects that can be changed, but I suspect that's not what the client is after today. They're looking for a restricted purpose company, and the BVI is the only company, the only jurisdiction that can offer that.
Thank you, David. So, Amber?
Well, that's definitely true, but the bank might think it wants a restricted purpose company, but actually, as the deal progresses, if they want to change their articles and they want some flexibility in the transaction, they'll actually find that that's not going to be possible with an RPC. So they could actually, ruin the deal by doing that.
That's true. There may be changes along the way, but I think we have a client here who is quite adamant that they do not want the objects to change. But I appreciate that in reality, you may find yourself in a position where the deal has to be restructured, and then you end up stuck with a company with objects entrenched that you don't want. So point taken.
Any other comment on Amber? No?
Guernsey.
So, Guernsey, David's absolutely right. We can't offer you the proposition of a restricted purpose company, but what we can offer you is fast and cheap, I'm pleased to say. So, or good value, should I say. In Guernsey, you're able to incorporate a company within 15 minutes, providing you use standard articles of association. So that clearly fulfills our client's brief to get the job done quickly. I can also point out to you that in Guernsey, the cost of incorporating a company is just $1,200. So in 15 minutes for $1,200, you can have your company up and running. David, perhaps you could tell our client what it's going to cost him to get an RPC up and running.
Well, I was going to leave that to the end, save the best for last, but there is a charge of $5,000 for a restricted purpose company in the BVI, but it's worth mentioning that if you want a bog standard company, a special purpose company, as you can have in Cayman or Guernsey or the other jurisdictions, then we can do that for $1,500, which is not quite as low as Guernsey, but I think is still fairly competitive.
But we can also, David, achieve the same things as you mentioned, by limiting our objects and limiting our articles. And with the recent unpleasantness in the financial markets, I'm sure you of all people would agree that it's helpful to be able to change deals down the track. You don't want to be too restricted in what you're doing.
I think ultimately no one wants something that's really fast and cheap, and equally no one wants something that's slow and really expensive. So what you should actually go for is the middle ground, where you have something that's going to be reliable and works and doesn't cost a fortune.
Okay, well, I'll leave it to our moderator to choose, and I understand that despite the fact that he comes from a particular jurisdiction, he's going to be neutral,
No, I'm
neutral in this exercise.
absolutely unbiased in this, absolutely unbiased. But I am, nevertheless, a slave to the client's instructions, and our client's instructions were that they wanted a restricted purpose vehicle. So I'm afraid that I have to award the prize for this particular part of the session to the BVI, because very expensively it offers a restricted purpose company option with objects which are locked in at the time of incorporation and which cannot subsequently be changed, and with the effect that it would be ultra vires the company and a breach of the director's duties to act outside that restricted purpose. So over to you for your grand prize of a black biro pen. So I hope you get the idea of the swing of how we're going to do this. It's just really, this is a compare and contrast, and as a lighter way as we can manage, because I can't really imagine that. So the next element that we've got to achieve is for the second SPV, known as SPV-B, is that the ultimate parent, which is going to be the ultimate direct parent of Starfish, is that it must be incorporated in a jurisdiction with a high reputation. Now, I've just finished telling you during my own introduction that all of these offshore entities within the Appleby Group meet the highest standards of offshore compliance, and so therefore, ipso facto, they all have good reputations. But there are particular historical things that I'm sure we can tell you about, and so in contention for meeting the particular criterion of being in a jurisdiction with a well-established reputation as an international financial centre, in contention for that particular prize are Bermuda, Guernsey, and the Isle of Man. So speaking for Bermuda is, I've got to remind myself now, is Alison, who will then be followed by, are you speaking, James, on Guernsey? No, sorry, you are. Francis is speaking on Guernsey, and then the Isle of Man, of course, is still Kyle. So over to you, Alison.
Wow. Bermuda, Jamaica, we'll want to take you down to Kokomo.
Was that the Bermuda,
Was that the Beach
Jamaica?
Boys song? It's Bermuda,
Is it?
Bahamas.
Tom
Oh,
Cruise,
is it?
Bermuda,
Yes.
Bahamas. No,
Yes.
Bermuda's in there as well.
Jamaica's, yeah.
Look,
Bermuda
I mean,
is-
we are the Volvo of the offshore jurisdiction world. We are established and reliable, and we are one of the oldest jurisdictions for offshore business. People know who we are. They're comfortable coming to us, and we've got a well-entrenched regulatory system. There is an organisation which vets beneficial ownership, and the vetting kicks in at 5% or above with the Monetary Authority of Bermuda. We require auditors, and if you want to transfer beneficial ownership, then government approval is required. So I'm not quite sure why you would go elsewhere.
Thank you very much. And then for Guernsey,
Well, Alison, several reasons why the client might want to go elsewhere here. You mentioned there's a 5% threshold vetting ownership above 5% in Bermuda. Well, that's 10% in Jersey, so there'll be far less unnecessary snooping around down there. Also, there's no auditor requirement when it comes to the accounts, so that makes things also far easier. And then no issue with government consents when it comes to transferring beneficial ownership. I noticed that's the topic you skipped over in your promotion. Jersey is obviously far closer to Europe and very well established and popular with investors. And also, and well, we're not going on holiday, are we? But, you might speak to Thomas Cook about that. And also recently voted number 1 of all jurisdictions globally in an International Monetary Fund report. And last but not least, has more Michelin-starred restaurants than Bermuda. Hosts a rugby team that was promoted to English second tier this season.
but the question is reputation as an international financial centre, not as a culinary centre.
But by the way,
Yes,
that
no, those
IMF
considerations.
that IMF report ranked all, not just offshore centres, but major jurisdictions as well. So when Jersey was ranked number 1 in the IMF report, that was ahead of the UK, ahead of the United States, ahead of France and onshore jurisdictions.
So actually, we ought to pause for 1 second, because although I mentioned something along those lines at the beginning, and speaking about compliance, in all seriousness, as David rightly says, the offshore jurisdictions, by reason of the unfortunate kind of taint that sometimes is associated with them, has to jump higher than everybody else just to stay equal, or actually less than equal. So the ranking of Jersey as number 1 in the world against UK, against USA, is actually quite significant. And what that means is that they try harder, rather like Avis. So. But that's not to prejudice the outcome of this session. Sorry, Francis.
Well, Francis and Alison, it's time I told everyone about the Isle of Man, really, I think. I'll give you a bit of background information. We're also a very well-established offshore centre with a first-class reputation. I think what is important is the Isle of Man is a very stable jurisdiction, a very safe place to do business, really. We actually have the oldest parliament in the world, or continuous parliament in the world. It dates back over 1,000 years, going back to the times of the Vikings when they ruled the Isle of Man. We've got an economy which is, despite the world recession, is continued to grow. And in fact, we've had actually 27 years of continuous growth. Unlike many of the other offshore centres, which specialise in particular areas, Bermuda insurance and Cayman and funds, the Isle of Man's a bit of a jack of all trades. We cover all the bases really, setting up offshore companies, the insurance sector, the funds sector. We also got into areas like gaming, aviation, and even space law. So we can pretty much match everything anyone really needs, really.
Jack of all trades and master of.
Well, some may say that. Some may say that. I like to think we're a master of everything, really. But going on to the sort of specifics of this particular question, we don't have any sort of government regulatory side where they check out who is the shareholder, who are the directors. What we have is the corporate service providers in the Isle of Man who set these vehicles up basically have to do checks on the shareholders. So anyone owning 10% or more of the shares in a company will have to be vetted. We don't have any auditor requirements over there, which is a bit of a bonus when you compare it to Bermuda, I guess. What we also have is, if you want to transfer shares in the company, there's no need to get government consent, which I know for a fact in Bermuda you need, and that can cause issues in a transaction. Who wants to hang around waiting for the government to sign off on a transaction? And we do have to file annual returns over there, which does have information on the directors and shareholders. So there is an element of openness with regards to that. So I think overall the Isle of Man is a great package.
So having heard from all three jurisdictions and, of course, declaring my own interest as a native Bermudian, I'm bound, of course, to award Bermuda with the prize for being the most well-established, having a well-established reputation as an international financial centre. And my reason for that is simply the length of recognition insofar as Bermuda, and I can tell you this as a